Good morning, everyone. Thank you for joining us today. Good morning, Elena.
Good morning.
So, we are cross-border legalities, and today we're going to provide you with an overview of the USPTO fee increase that is coming up in January 2025, and which are the added factors, the reasons behind the increase, another little items that are going to help you understand your filings in the US for next year. I would like to open up presenting our law firm. We started in 2022. Let me just go back. Navigating the USPTO trademark fee changes effective January 18, 2025. So let's understand the key changes and strategic implications. About cross-border legalities, we established the law firm, the law practice in January 2022, and we specialize in cross-border corporate commercial transactions and intellectual property. We do have we factor in some business immigration. We mostly serve clients from the US, Canada, Mexico, Brazil, and Colombia. We also served clients from India, China, and Europe. Would you like to introduce yourself, Eliana?
Hi, everyone. Eliana Torres. I've been practicing for about 8 years now, mostly trademark and copyright law. We are here happy to have you all hear our side of the changes and listen to how we can avoid some of the surcharges and new fee changes that will be coming up soon. Short and sweet.
Thank you. And my name is Nancy Leon. I'm the founding partner of Cross Border Legales, and I practice as well intellectual property, mostly trademarks and copyrights. And we offer services from trademark filing and clearances, response to office actions, maintenance and renewals. We do a lot of WCAG proceedings, IP licensing, and dispute resolutions. And we're going to start. I, I think I'm
Yep.
going to leave you, Eliana, to start.
Yeah, I'll give a brief overview of what's going on. So, the trademark office recently decided they've been considering for a couple of years now to increase the fees in a different way. These new changes are going to come with an adjusted 28 trademark fees that include the 7 new fees that we have never seen before. So this is a significant change from and withdrawn from what we usually pay, which is a basic fee, and then just the separate fees for maintenance and for statements of use support. So this new fee is going to affect January 18th. There's a different date for Madrid applications, but not to complicate, just keep the January 18th date to mind, which is coming up soon. So how are these adjustments going to happen? They're going to be different fees that we're going to go back into, but it's basically more structure. It's not going to be just one basic fee. It's going to be additional fees that are going to break into the process or be added into the process. So there's some surcharges as well, which we've never seen before. Would seem like penalties, but this is kind of trying to enforce the process of having some more consistency with the application. So the initial application, having complete applications, making sure there's not a laundry list of goods and services. So I think the trademark office is really trying to hone in into having complete applications that don't delay the process of examination. So next slide. Also, the images here have been made with AI. So if there's any issues with the wording there, it's AI doesn't recognize good grammar yet. But go on.
Okay.
So this is just a quick overview of how the new fees were decided. There was a discussion in the trademark public and where they have trademark public meetings where they invite the public to kind of comment. And there's a very strenuous process into how they actually finally issue these new fees. And I'm not gonna bore you with the details of how the process goes. Very bureaucratic, but finally they decided that this finance model, which is what I explained earlier, where they collect most of the fees at the front, which is the basic application, was not really um, being complementing the additional examination time that it would cost to uh, examine some of the incomplete filings or some of the more complex filings. So they decided this will be the best model. So changing the model to collecting fees and the surcharges and the new additional fees, and not just one basic application fee. So this is a quick overview of how they decided. This actually is one of the slides that they prepared for the TPAC meeting from June 2023 before they actually decided to make this fees final. Next slide, please.
Yeah. There's something really
Oh, yeah, go
interesting
ahead.
that you were explaining me earlier about the example how you file for a trademark and you pay the initial fee, and if the application is quite complex, like quite complicated with a very long list of items, and you have to get back to the client or the applicant and ask them to adjust, correct, you go back and forth with the applicant. So at that point, as you said, they only had charged one specific fee and they don't have an opportunity to collect more fees.
Mhm.
That was,
Yeah, yeah, and that's exactly it. The main, I from reading the notes from attending some of these meetings, that seems to be one of the main reasons driving these changes. They will just want to make sure that the examination time is actually commensurate to the fees that are being paid. And the next slide kind of goes a little bit more into that. Uh, so there's a streamlined, yeah, so this is kind of where the collections are paid, mostly at the beginning, which is the application fee. So we're now going to see an additional the additional fees for those more complex filings, so that it's commensurate with the time of examination. And this is also another slide from their presentation during TPAC, where they kind of were explaining the reasons behind increasing these fees. And these fees,
okay.
as I mentioned, are gonna have a different intervals, and this is the way they explain it. The fees are going to occur at different intervals to be commensurate with that examination time. And if you go to the next slide, we'll get into the nitty-gritty.
Okay, trademark application filing fees. This is gonna get scary. Right, so we have the application filing fees in here that today we understand the application filing fee. So we have two options. We have the TS Plus and TS Standard. So you can start filing with 250. The USPTO provides you with a specific list of description of goods that is kind of, it will limit but include most of the items that applicants wish to protect. And then the 350 filing fee, which means that applicants can enter or include their own description of goods. And starting from January 18, 2025, the new and only filing fee will start at 350. There's not going to be a 250 TS plus anymore. Is that
Yeah.
correct?
That is correct.
Yeah.
And I'll go a little bit over strategic filing here. Normally, my preference is to pay for the 250 for businesses or entities or individuals who have very specific lines of business that are not in the ID manual. And what I mean by the ID manual, if you're not familiar, is the identification of goods and services manual, which the USPTO uses to kind of have the standardized description of goods and services. So when you file for an application, let's say for entertainment services in class 41, they're going to have a pre-description, so entertainment services in the field of, and then you fill in whatever it is that you're doing. I normally like if you have a very specific kind of industry where there's not really necessarily something that fits into the mold of the existing ID manual. I like to pay the $350 so that we don't have to face additional fees in the back end. So there will be, if you pay for the 250, which is the TIS plus usually, which is a standardized application to make the process a little bit more streamlined, like they want to in the with the new fees. You basically will have to pay an additional fee if you don't meet all the basic requirements from TIS Plus. So it simulates the new standard fee. So what I mean by that is TIS Plus requires you to use the ID manual, so use the standardized filing ID manual descriptions, and to make sure that if there's an individual, to have the signature of that individual from the if there's an individual in the mark. So your name is in the mark if you're filing for Mark Jensen or anyone in for a trademark, then you have to have the consent of that individual in that trademark. If you do, that's just an example. But if you don't have that signature, then they'll kick you off T's plus, and they'll add the additional fee. So they'll charge you an additional fee. So the strategic filing that we normally like to do is basically if you have a very to avoid any fees that we are unforeseen or any issues that we may not have caught at the beginning, the strategy there will be to file for the $350 and allow us to fill in the identification of goods and services to make it molded more specific to the client, and to make sure that all the details that are required in the application do not make it an issue later on that will require additional fees. So I know it sounds a lot complicated, but basically what I'm saying is it's more beneficial to have that upfront payment of 350, in my opinion, where you can fill in your own description of goods and services, because you predict that that's the only fee that you'll be paying. But that's for if you have a very specific business that's just clothing, or this is clothing, shirts, names, etc. That's how you describe it in the application. Then that would be a little bit more strategic to pay the 250 and save some of the cost up front. But with this new, they're getting rid of the this plus. So with this new change, this kind of buckets us into a 250, or the requirements that normally will be required for a T's plus, which is a 250 charge. All that to say that the new fee is a little bit more restrictive, and it does not give you the freedom to basically add your own ID or into the application. Hopefully that's not too complicated, but open to questions if anyone has more questions about that.
Yeah, please shoot your questions, like drop them in the chat, so we'll be able to address your questions at the end of the session. So
So
we're
this is the
going
fun
to,
part.
yeah,
Go
this
ahead.
is the fun part, the trademark application surcharges. And something that is very interesting, and I want to make a note in here that everyone thinks that the only increase in the filing fee, it's $100. So even if I have communicated a notice saying like, please hurry up, we should file before January 2025, 2025, like uh, kind of encouraging all applicants and clients to do this, they come back and tell me like, no, there's only going to be $100 more, or maybe, they don't really see the difference of it. Like they don't really understand that it's going to be new surcharges that we don't know, that before they didn't exist. So we're gonna go and see the nice thing in here. How it keeps on adding. It's like a little machine, like ting. So these are the new surcharges for electronic filings. Obviously, they're higher if you're filing by paper, but we normally don't do that anymore. Um, insufficient information is going to be $100. Custom identification of goods and services. Now, if you want to enter your own description of goods and services, which is not using the trademark list provided by the USPTO, then you have to pay $200, and that is per class. And each additional 100 characters is an additional $200. So a thousand characters in the description of goods and services. If we see like 1,000 characters, you might think it's very broad, but it is not. So we're gonna see some examples on the next slide about the surcharges, and see how limited is the 1,000 characters description.
And interestingly enough, in their final the final note with the fees, they mentioned that they include punctuation, and so in the semicolons that we normally would separate each one of those items, and the identification of goods. If you've seen an application, we normally have clothing, etc. And then we have shoes, and so these semicolons and spacing and punctuation is basically going to be included in the character description, which is very limiting.
True, true. I completely agree with you. And we are going to go in our next slide, understanding the insufficiency information fee. The definition of the 100 surcharge applied when an application fails to meet any of the 19 specific requirements. So let me tell you, you might think that these 19 specific requirements uh, are 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 very objective, but some of them they're not, and the likelihood that we're gonna get a surcharge of $100, it's a fact. It's high, and we were discussing that previously. So some of the key required elements for base application. Would you like to go through all of them, Eliana? Please, yeah.
Yeah. So usually these are just mandatory requirements which simulate kind of the T plus requirements often. So which some additional items, but the applicant name and domicile address, these are things that are normally missed. So kind of mismatch of the name. So having, let's say, XYZ Company Inc., but then the entity is the described as a LLC. So those mismatching issues, that will be one of the examples for the first one. So the applicant's name and domicile address have to be there. Um, Same with the second one. So you have to have the citizenship of the partnership has to be there, for example. So you have to make sure that all citizenship information and the status of the legal entity is provided. So whether that's a domestic partnership or any partnership, a sole ownership, that also has to be uh, very specified and making sure that you have the citizenship of the owners. So those are issues that are normally seen in just the basic application, that they're now going to charge $100 if you don't have those perfect at the start, basically. The the filing basis compliant with 2.34. 2.34 basically describes the base filing basis. So basically, whether you have an application to use for intent to use, 44, so an international foreign registration that you want to extend protection in the United States. If you don't have the correct basis, or if you file or you don't include a basis, so sometimes you see applications without a filing base. So they either forgot or strategically put no filing basis to wait for the examination and then actually add the basis. So basically, I've seen that from the examiner side. So when I was an examiner, I would see a lot of applications that would come in without a filing basis 1A or 1B, and they will be adding the basis. Just I would see it as a strategic reason for it, whereas they would decide they wanted application in use, or they wanted to use a foreign registration, they wanted to wait for that examination additional extra time, and then tell the trademark office what they were doing with the trademark application for the basis. However, this is now going to be charged. So that strategic or that strategy is not going to be available without $100. So that will now be charged an additional part of the surcharge fees. The next one is the filing fee for each class of goods and services. Sometimes we would see also part of what I think is strategy is you have a laundry list of let's say clothing and entertainment services only in one class, and that will be based on one in the examination process to tell you basically to tell the applicant what classes will be accepted and which would not, and then they would tell the applicant you need to pay for this additional extra classes, and then at that point the applicant decides, okay, yeah, I want to pay for this extra classes, or the application was refused only for this specific classes, so I only want to pay for the ones that did not receive a refusal. So now that's not going to be an option. So now you're gonna have to pay for the exact amount of classes that you select or that you include in the application. So now you have entertainment services and clothing and mugs for drinking. You're gonna have to have each one of those fees for each one of those classes, and not wait for the examination process to tell you which ones are accepted, which ones are subject to refusal. So that strategy is also gone. The next one will be again, this is kind of in part with the last this what I just described, which is making sure that you have each one of those goods and services in its proper classification, which is why they're really emphasizing the need to use the ID manual and to go directly taking those descriptions from the ID manual instead of writing them in. I think that's why The surcharge is only $100, where the ability to write in your own goods and services is $200. So you could write in your own description of goods and services, but then that will be $350 for the basic application plus $200 to write in your own goods and services description, which adds up. So now I think they're trying to kind of really enforce that they want to use the manual so that the examination process takes less time, because deciding what would be a proper ID takes a little bit more of examination time. The next thing would be the color and description of the mark, basically. So if you have a drawing with color, and you have to have a description of the mark that identifies those colors. So let's say I submit this trademark uh, or this image that I that was created with AI on the right side as a logo to be trademarked at the office. I would have to describe every single one of those colors. So the mark consists of a circle with in color yellow, or with the gavel in color brown, with a, a gold inside, or whatever you want to describe it as. But if you don't have that description at the in the application, at the upfront process, then you have to pay that $100. And this is something that's missed often. um, During my time at the USPTO as an examiner, I that was one of the issues I saw recurrently, and I don't think it was intentional. There was no strategy behind it. I just think that you kind of forget that you have to include the colors in the mark description. And it was something simple, like, they did have the mark description, like this is a logo that has a, money signs, etc., but they forget to identify the colors in that description. And often it happened in the reverse. So let's say you had a mark that's black and white, you don't want to claim any color. You will have a description that had color, that described the color, like the markets in black and white. You don't have to include that the markets in black and white. You just kind of have to have the mark description, or like the markets in blue or red. You just have to say the markets in black and white, and make sure that the mark is actually in the color that you submitted in. So that's the mark description. And I know that's like really complicated sometimes, but it really doesn't have to be. It's just basically submitting the mark as you're going to use it. And if you're not going to claim any color, make sure you submit that as a black and white drawing. The next thing is, if the mark is in standard characters, or you have to have or in non-standard characters, you have to have a description of the mark. So again, this goes with what I just said. So if you have a mark that is stylized, highly stylized, not just the standard characters, which is not the word, then you're gonna have to have the description of the mark. And if that's not included in the application, again, $100. Then we go into the words that are not in English. You're gonna have to provide a translation if the mark is not in English, and if you don't provide that translation, which sometimes you don't provide it purposely for strategy reasons, then you would also have to pay that $100 fees now. So sometimes maybe you have a mark that is in a different language. You don't want to provide translation because there might be multiple translations for the word, and you want to wait for the trademark office to tell you as the client or the applicant that this is the specific translation they want on record. Then you wait for that translation to come in as part of the office action or the examination process. Now we have to provide a translation whether we want to wait for the examination process or not, and otherwise we pay that $100 surcharge. Same with non-Latin characters. So that's takes the same treatment as a foreign translation. And the last thing would be what I mentioned earlier as an example, which is the individual name or likeness consent. So if part of the mark includes a name or even an image of someone that's a living individual, you are going to have to provide a statement of consent for that individual that to allow the trademark to register with their name and likeness. And if it's not a living person, then you just say it's not a living person, but this statement has to be on record and has to be part of the application if any part of the mark could be construed as identifying someone. So I know that's a lot.
Yes.
It's 19 requirements, and I try to go as fast as I can through all of those. But all of these, if these are missed, they're gonna be facing a $100 surcharge, and Nancy is going to tell us why that's an issue.
Yes. Well, it is great that you mentioned, because you were formerly a USPTO examiner, and we were discussing this early in the morning, that these surcharges, like for example, the $100, there might be things that we miss, but there might be others that are very subjective, such as description of the trademark. Sometimes you're going to get a, a correction from the examiner asking you to make a different description. However, the description that you submitted is some description that was already submitted for previous applications that were accepted and that were registered. And also the colors. Maybe you enter orange and they might come back to you as no, this is not orange, this is red. It's very subjective. So the likelihood that the surcharge will be into your trademark application, and most likely when we file for like logos, it's is actually very high. So it's something we need to consider. It is that's that's what I think this is going to happen. So the issue would be like how we're going to charge to our clients when we file the first application and we consider these things. And because some of the clients might think, oh, this is an issue from the filing attorney, right? That you should, but is nothing like that. There's not a perfect application. There's always going to be issues. There can be a dot missing or a comma in the description of goods. So I think this could be, I will consider already a fee charge, like a surcharge, as a standard when filing for a logo or a design, because this will likely to happen. Okay, I'm gonna go for the next slide. Hold on. Okay. Okay, we are here. Okay, I think we went through all of this, right?
Yeah,
Understanding the
yeah,
insufficiency.
we just went over kind of common omissions that we see in applications that would probably require us to pay that additional fee. And if there's any questions, again, thanks for the Q&A, Nancy, for putting that in the chat. But yeah, we're happy to answer any specific questions. But I think Nancy went over the impact, and we move on to the next slide.
Exactly, yeah. I mean, but you were pointing out to the key elements in here. Yes, I mean the lack of statement, but okay, incorrect description, especially in the sign marks, that is going to be an issue. Character count and surcharge. This is
Yeah.
very interesting. So, yeah, so understanding the character count and surcharge. So the policy asks you that if you are only allowed to get into 1,000 characters, but anything additional is a surcharge applies to for each additional group of 1,000 characters in the description of goods and services. So beyond the first 1,000 characters. Inclusions characters will include letters, numbers, punctuation, spaces. So we come up with a description of goods, and in here is on class 09 is downloadable computer software for managing personal finances. So as you can see, I'm not going to read all of the description of goods, but there are certain classes that will require a lengthy description. And it's not because the applicants want to enter like a very long list, but because of the nature of the goods and services, you need to enter a lengthy description and in order to make sure that you protect all your ankles of your trademark. So the likelihood that for those classes that they're going to go over the 1,000 characters allowed, so the surcharge will apply. Maybe some applications will have this problem, but others, and most likely a lot of them, will have. So now we're talking about that from the 350, if you're filing a logo mark, then you add those $100 because the likelihood that you can get probably a correction about the description or maybe some colors might be high. And then at 200 if you include some of the classes that are very lengthy character. Yeah. So please go ahead, Alina.
No, I think it's going to be. I've been trying to search kind of applications in which I think are good examples of what that would look like. And I think it's is roughly about, including the spacing and punctuation, is probably around 150 to 200 words, which is quite limiting from what we've seen before. So it almost seems that if you have a very complex industry that or very complex application in your client in the emerging technology sector, or a technology or a sector that's not normally evidenced into the manual, the pre-existing description of goods and services, then I would hesitate to say the $200 would not be worth it. So I think that maybe the $200 to write in your own description um, could be worth the surcharge. But then for this character count, it may just be that we just just add the fee basically. So count the $200 into the potential filing fees that will be required, if we're not going to go around this. I think some clients or some applicants will actually just let the surcharge come to them basically. So then they'll keep the class description very lengthy, and then they'll just pay the $200 to avoid kind of having to constrain themselves into specific categories. Um, I wonder, there's some questions from multiple attorneys about how this is going to go about it. And one of the questions that I've seen kind of ruminating about is whether those descriptions that are over the 1,000 character count, would they be allowed once they pay the surcharge? So would they allow the application to move forward with over the 1,000 characters, or would they is it just something that for each class basically? So would they allow the application to move forward with just $200 in each one of those classes that has a laundry list, a very long list over 1,000 characters? Would they allow it to move forward, or would it be $200 per class? So those are questions that we still don't know how the trademark office is going to be treating these filing fees, but we're hoping that it's one of just a $200 surcharge fee. So basically, if you have multiple classes and you go over the 1,000 character limitation, then you could potentially just have that laundry list in each one of those classes, so you're not just basically paying for one class surcharge. I hope that makes sense. But yeah, this is very limiting. I think 1,000 characters to include spaces and punctuation is basically a very limited description, which I think they want to continue enforcing in the office.
Okay. So we're going to go next to the additional charges. These are not additional charges, but these are some of the increases that we're going to see next year. Amendment to alleged use and statement of use fees. So we're seeing an increase in here from $100 to $150, 50% charge. In the statement of use, it's actually 100. Yeah, it was 100. Amendment to this, yeah, 100 to 150. That is true. So there's going to be an additional $50. I'll go
Yeah, and
next.
just to do you want to give a
Yes.
brief overview why that's in on the statement of use, and how that's basically going to basically if you file an application for intensive use, which we have a lot of those, we're just going to be including an additional 50 in the calculation of how much it is likely that you're going to pay, because you are going to have to file a statement of use. I think this affects mostly the applicants with an intent to use mark. The amendment to alleged use, that's normally done for strategic reasons, but for applicants with an intent to use mark, I think we need to calculate into our estimate of fees the $50 extra, because that's just going to be part of the additional fees. In addition to the 350, any potential surcharges, now we're going to add the $50, because we're going to have this is an increase that's just blanket for all applicants. So that increases the calculation for a final kind of estimate of how much we estimate for a client to pay overall. But go on, sorry.
Yes, it's going to be high, and I completely agree because
Mhm.
you start at the point of the 350, right? And then nobody's looking at the 350. They say, okay, there's no change, but then you're going to charge another 100 if there's any issues with the applications, if there's any descriptions that need to be amended. Then another 200 if we go over the description of goods and services, so that you make it. And it depends if you want to include the ID manual description of goods and services, then you get another charge of 200. So you go increasing, like you're already at 750 in there easily. I think if we continue thinking that we're going to start at 350, we're not going to hit the 750. That's a mistake. I think these surcharges are going to start counting because on the daily practice you see this, and this is something that was not charged previously. Okay, we go to the next slide, is post-registration maintenance fee. Uh, Please go ahead, Eliana. You can go through all of
Yeah,
them.
so
Yes.
for yeah,
Yeah.
I think these are just blanket fees that are going to increase. There's not really any strategy here, any kind of formula. This is just a blanket increase in the fees that we normally file for maintenance of the trademark registration. So um, a lot of these are just $100 extra for or actually even 50. The fees from 25 to $100 extra in some of these changes, some of these filings. But really this those blanket changes, the adjustments are just across the board. There's no interval surcharges, kind of like what we're seeing in the application process.
Yes, that's true. Okay, this is pretty. Additional fee adjustments. We have the petition to revive, the appeal to TDAB, and the letter of protest. Uh, I believe these are like, these are like slight changes into the fees. There's nothing new on it. And yes, the same as previously, you just added like $100 or like
Yeah. The one that's most
but
concerning to me. Oh, go ahead.
the
Yeah.
letter protest, yeah, the letter of protest went up from 51 to
Yeah.
150. That's a
Yeah,
lot.
that's the one that's the one that's the most concerning. I could understand the post registration fees because they haven't been changed in quite some time. I mean, neither have these, but the letter of protest, which is not often used, which is surprising why they will increase it so much. I don't know if they want to discourage the use of letter of protest, and letter protests are actually quite helpful when you have multiple marks that, or you have a mark that's potentially used widely. Um, I would say that's the most surprising for me, and that is the most concerning. So I don't know if they want to discourage the use of letters of protest. I couldn't see anything in the final note that they released. If there was any mention of why that was so high or such a wide increase, because normally you're seeing the changes in post registration from like $50 to $100, but you're seeing this $100 for just the letter of protest, which is quite interesting that they decided to go that route.
Okay, yeah, that's true. So, strategic considerations for applicants. Yes, we go to that. Please file before January 18, 2025. Encourage all your clients that is in their own benefit to file before that date. So they don't want to see all these added fees that we can still avoid. Avoid new surcharges for insufficiency information or lengthy descriptions. That is going to be a tough one. I think even for attorneys, when you file an application, you the best that you can, even in the description of a trademark, entering all the colors and making sure that everything is in there. And sometimes you get back a slight corrections. So this is going to be very difficult to avoid. Application preparation, ensure all required information is complete and accurate to avoid surcharges. Be concise in the description to stay within the 1,000 character limit. I think this can be doable. I'm not sure how that's going to play once you get the 1,000 characters and then you get back, or the examiner will get back to you and tell you, oh, you went over 1,001 characters because you were missing a comma or a dot. Are we going to be able to delete some of the description of goods to adjust the 1,000 characters? And just think about it, like just doing this type of work, going back and forth and discussing the 1,000 characters. Um, we're going to spend more time into the applications.
Yeah,
So that
I think it's going to incur more time for examining for us instead of the examining attorneys. I think the examining attorneys will have an easier time moving forward.
and also to communicate these added charges, other fees. Yeah. So budget planning, account to increase costs in 2025 and beyond. Consult with experienced driver consult to navigate the new fee structure effectively. Something that I might say that a lot of the clients might not be, like most of our clients from Latin America, uh, y- these changes will really impact their budget. Like maybe like bigger companies, one really, they have to pay those charges, they'll pay for them. They just have to adjust their budget. But like the smaller clients, the startups, the smaller companies, the individuals will see a hit in these charges. First of all, because obviously most of the Latin American currencies are lower than compared to US dollar, and and already 350 plus the attorney's fees was a high price for them to pay and maintain. And now this is going to be surcharges. It's going to be difficult for some of them to want to protect their trademark in the United States.
Yeah, I have nothing to. I think you kind of just hit it right on the head. I think that we're gonna see a lot more discouraged clients with the process in the United States and may choose or other jurisdictions for protection. Um, but I do think that there's some strategic considerations for fighting in the United States and try to avoid those fees. And I think some of that touches on some of the questions we have in the Q&A. So Nancy, if you want to go over that.
Okay, let me go to the Q&A if you allow me. I'm not quite sure. I can't see where's the Q&A in here. Can you see it?
Yeah, so I'll read the
I'm not sure.
question off. So
Oh, please.
how can applicants effectively manage their descriptions to stay under the 1,000 character limit without risking rejection or for insufficient detail? So, um, one, having a pre-filing description that, and it could be just as rudimentary as having it in a word count and making sure we count the spaces and the punctuation. I think we're just gonna have to see how the office treats having additional spaces or less spaces between words. Now using like that semicolons to describe words. So I think that now we should have um more concise descriptions or more specific descriptions. Nancy, I don't know if you want to add to anything, but I think that like there's just no strategy that could be included there other than just to try to have a very specific description or try to use the manual in combination with some of the additional details from the that would normally be in the application description. But I think it's just we're just gonna have to count.
Yes, we will have to count and I mean it's also new for us. These other fees are going to be new for us, and we're gonna start getting familiarized with it. Yeah, it's gonna be hard to avoid some of these added fees. The way that I see it is only on the character limit count, and also maybe using the ID manual. That would be a plus, and being more, yeah, be. I really, I wish I could say more about this, but I think the reality will be that your filing application will end up being 750 instead of 350. So it's
Yeah.
something that we need to sink in, because if we start saying, and this is something that probably some applicants might want to do, I want to keep the 350, but that's not going to be possible at some point due to all these added features that we need to consider.
Yeah. And
Yes.
that's a significant jump from what normally would be 350 per application. Now, considering all these fees, it's a significant change and increase.
Yes, there's a significant increase in here. I do have a lot of like filings starting from 250, a lot of them. And I do a lot of applicants have that they are very caring and very specific and very limited of the goods and services description. But yeah, now it's going to be gone in January 18, 2025. So,
Yeah.
uh, um, okay, so I think this is our last slide.
Yeah.
I would like to encourage our audience to send us your questions. Also, we have a promotion. We're gonna go if you want to file this year and before January 18, please contact us. We're providing with a 40% discount on attorney's fees. So we would like to encourage to file your applications with us. Um, Send us any questions that you may have. We are going to do our best to respond to them. Like That said, because we haven't experienced these new charges, so some of our responses might be limited to our experience or to what we understand. This is gonna go. We're gonna start like getting more familiarized with that once we start hitting January 18.
Yep. So just take it as a we're trying to help our clients here to make sure that they save some additional cost. And so any maintenance registrations that are due for maintenance or ripe for maintenance, please file those before the end of the year if possible, or beginning of next year before this new changes. Any statements of use that are due or any allegations of use, so if you want to change the application to being used, any of those, any of what we mentioned earlier, just do it before, just because we also as trademark attorneys don't know how the office is going to handle the charges, the new charges and the new fees and the new surcharges, and whether that's going to be a surcharge per class, which may be past the 750 that we're considering. We don't know. We don't have a lot of questions. I mean, a lot of answers to questions about how they're going to calculate that per class so insufficiency fees. So our best recommendation right now is to get ahead of it and file anything you need to file before January 18th. So that's the best advice we could have right now.
Yes, that's true. So thank you everyone for joining us. We are closing the session. I think we went over the 30 minutes, but it's good because we went through each key items in these like new fees. If you have any questions, please feel free to reach out us. Our contact is on the chat. I don't know if so we have your
Yes,
registration. We have recorded this session, so we're going to share it. If you want us to share the recording, we're more than happy to share them with you. If you want to contact us, if you have any questions, we're here. Um, we can send everyone an email. So thank you.
yes.
And anything else, Eliana?
No, any
Would you
questions,
like?
please send us to our email. We'll be happy to answer them.
Okay. Thank you. So this session is
Thank you.
closed. Thank you so
Yeah.
much.
See you soon, Nancy. Bye.
See you soon. Bye.